On behalf of our committee and the Committee on Communications and Media Law, our two committees organized the event for tonight. We'd like to thank the committees that have helped by co-sponsoring the program: the Committee on Consumer Affairs, chaired by Jeffrey Greenbaum; the Committee on Entertainment Law, chaired by Robert Harris; the Committee on Sports Law, chaired by Martin L; and the Committee on Trademarks and Unfair Competition, chaired by Brett Parker. And I'd like to ask Craig Bloom and Naomi Gray, who coordinated this program, to introduce the speakers. Thanks.
Thanks, Ed. We're thrilled that one of our panelists, Rick Kernan, has agreed to take the moderator's seat tonight. Rick's a partner at Frankfurt, Garbus, Kernan, Klein, and Sells. He's fought at the front lines of some of the leading cases in this field. He's litigated right of publicity cases involving celebrities, including Vanna White, Woody Allen, and Jackie Onassis. His copyright cases include the recent battle over the novel The Wind Done Gone, inspired by Gone with the Wind. And Rick will start us off in a bit with a terrific show and tell. Our panelists tonight include Johnnie Cochran of the Cochran firm. Johnnie's one of the leading trial attorneys in the country and arguably the most famous. His high-profile clients have included Michael Jackson, Sean Combs, and of course, O.J. Simpson. Of special interest to us tonight is Johnnie's representation of the civil rights legend Rosa Parks in a right of publicity case that she's bringing against the rap group Outkast that's used her name in a song title. Johnnie himself has acted in movies and television, and his own persona has been evoked in other works, including parodies, and, as you may know, the Seinfeld character, Jackie Childs.
We're also pleased to welcome to our panel Jay Kogan. As Deputy General Counsel for DC Comics and Mad Magazine, Jay sees both sides of the issues the panel will be examining tonight. Jay protects copyrighted material featuring the likes of Superman and Batman. But Jay's clients, especially the parodists at Mad Magazine, need to build on the works and personalities of others to create new works. We also have with us Richard Masur, the actor and former president of the Screen Actors Guild. Richard has appeared in more than 40 feature films, more than 40 television movies, and many popular TV series, including Picket Fences, Rhoda, and One Day at a Time. He has also guest starred in many network television shows, including Law & Order and The Practice. And Richard directs as well. In the right of publicity arena, Richard fought to strengthen California's law regarding deceased personalities. And finally, please join me in welcoming to our panel NYU Law Professor Diane Zimmerman. Diane was a journalist before attending law school, and she now specializes as a First Amendment, intellectual property, privacy, and tort law. Diane has written extensively about the right of publicity. In a pending case you'll hear about this evening, involving the sale of artwork depicting Tiger Woods, Diane authored a brief for 73 law professors, arguing that the First Amendment protected the sale of the prints. And now for an introduction that will really bring these cases to life. We present our moderator, Rick Kernan.
Thank you, welcome. I'm going to try to, as briefly, always difficult for a lawyer, as possible, introduce you to some of the cases that the rest of us up here will otherwise probably talk about in shorthand.
And I'd like to ask Craig Bloom and Naomi Gray, who coordinated this program, to introduce the speakers. Thanks.
Thanks, Ed. We're thrilled that one of our panelists, Rick Kernan, has agreed to take the moderator's seat tonight. Rick's a partner at Frankfurt, Garbus, Kernan, Klein, and Sells. He's fought at the front lines of some of the leading cases in this field. He's litigated right of publicity cases involving celebrities, including Vanna White, Woody Allen, and Jackie Onassis. His copyright cases include the recent battle over the novel The Wind Done Gone, inspired by Gone with the Wind. And Rick will start us off in a bit with a terrific show and tell. Our panelists tonight include Johnnie Cochran of the Cochran firm. Johnnie's one of the leading trial attorneys in the country and arguably the most famous. His high-profile clients have included Michael Jackson, Sean Combs, and of course, O.J. Simpson. Of special interest to us tonight is Johnnie's representation of the civil rights legend Rosa Parks in a right of publicity case that she's bringing against the rap group Outkast that's used her name in a song title. Johnnie himself has acted in movies and television, and his own persona has been evoked in other works, including parodies, and, as you may know, the Seinfeld character Jackie Childs.
We're also pleased to welcome to our panel Jay Kogan. As Deputy General Counsel for DC Comics and Mad Magazine, Jay sees both sides of the issues the panel will be examining tonight. Jay protects copyrighted material featuring the likes of Superman and Batman. But Jay's clients, especially the parodists at Mad Magazine, need to build on the works and personalities of others to create new works. We also have with us Richard Masur, the actor and former president of the Screen Actors Guild. Richard has appeared in more than 40 feature films, more than 40 television movies, and many popular TV series, including Picket Fences, Rhoda, and One Day at a Time. He has also guest starred in many network television shows, including Law & Order and The Practice. And Richard directs as well. In the right of publicity arena, Richard fought to strengthen California's law regarding deceased personalities. And finally, please join me in welcoming to our panel NYU Law Professor Diane Zimmerman. Diane was a journalist before attending law school, and she now specializes as a First Amendment, intellectual property, privacy, and tort law. Diane has written extensively about the right of publicity. In a pending case you'll hear about this evening, involving the sale of artwork depicting Tiger Woods, Diane authored a brief for 73 law professors, arguing that the First Amendment protected the sale of the prints.
Well, here on short notice, I wanted to make sure I got a good seat, so I said, okay, I'll do it. Tell you a little bit about what goes on as a comic book publisher and Mad Magazine as well, just in terms of the practicalities that are involved in determining what we allow to publish. Our artists and writers, they love referencing popular culture. They want to include references to real people, real song lyrics where applicable in the comic books, as well as perhaps real, it's a funny term, but real fictional characters. Spider-Man, Mickey Mouse, whoever else. When could they do this? When can't they do that? What kind of advice do we give them? On the Mad Magazine side, everybody recognizes Mad as parody. It's much less of a concern in terms of using celebrities in Mad Magazine. There we made sure that they are in fact being parodied and it's not just a gratuitous use. But in terms of calendars, just a comment on Mad, one of the interesting things about Mad is we feel Mad very strongly as an editorial, it's a publication, First Amendment protected. Where do you draw that line distinguishing editorial protected First Amendment media from merchandise? The cartoons case up there is a good example where that was held to be first protected media. Now, if they came out with a Treasury Bonds bobblehead doll that said Treasury Bonds on the bottom, and maybe a couple of the words from the back of the card in terms of the First Amendment protection, would the court have found the same way, protected by the First Amendment, or would that be a right of publicity violation? So with Mad Magazine, if you want to merchandise things, that's some of the questions we would concern ourselves with. For example, in calendars, you want to make sure the calendar includes editorial content to go along with the picture. Again, sort of the reasonable relationship issue that Richard had mentioned before. In terms of the comic books, in terms of real people, I think rights publicity, you have a much greater First Amendment protection there than copyright infringement. Using somebody else's fictional character is usually going to be a greater concern than using a real live person. But the real live person issue comes up in two ways. It could be a situation where our artist or writer wants to base a character on a real person. Either their likeness, they might want to use some photo reference of a famous actress to make Wonder Woman. Character's still Wonder Woman, but maybe that famous actress will say, you know, those cheekbones look like my cheekbones. Are we concerned about that? What do we do about that? Our goal in-house is to avoid lawsuits, not to win lawsuits, although we've won numerous lawsuits. If you type in DC Comics and Lexus or Westlaw, you'll find plenty of cases. But the goal would be to avoid lawsuits. So we would try to persuade the artists to change those cheekbones if brought to our attention. We try to make sure the artists, the editors know what they should bring to our attention. The other way a writer might name a character after a real person. There was a case in St. Louis last year involving Todd McFarlane, who was the creator of Spawn. You may know Todd McFarlane fame because he bought Mark McGuire's 70th home run ball. So you can tell how well he did in the comic book business. He made plenty of money. How valuable that ball is now, I don't know. But he created a character named Tony Twist in his Spawn comic book. Now, Tony Twist, the character's name was Antonio Twistelli, but also he named Tony Twist. In the comic book, he was a vile, vulgar mobster. It was a real Tony Twist who was a hockey player for the St. Louis Blues, and he had a reputation of being an enforcer, somebody who would, hip check particularly hard and things like that. He sued Todd McFarlane for naming the character in the comic book Tony Twist. The district court ruled in the hockey player's favor and awarded him $24.5 million, even though the character in the comic book was not a hockey player. He did not look like Tony Twist. It went up on appeal. The circuit court, Judge Robert Dierker Jr., ruled that the jury's verdict was manifest against the weight of the evidence. And in one of my more favorite quotes, no rational person could believe that the use of plaintiff's name as the nom de jour of a swarthy mafioso in a comic book series having absolutely nothing to do with hockey either benefited the defendants or injured the plaintiff in any way, except perhaps in the plaintiff's imagination. But it had to go up to the circuit court for that decision. So, in advising artists and writers, you want to try to avoid having to go to the circuit court to win your case. And there, I would look at it and say, well, is there any reason to use the name Tony Twist? Is it going to sell more books? If the answer is yes, well then, perhaps you've got a real problem because now you're using the name to sell the book. If it's not going to help sales of the book, why use it at all? Why ask for trouble? So we suggest you take it out. In terms of the other way you use famous people is use them as themselves. So you want to make it look realistic. Clark Kent or Superman, ends up being a guest star on the Jay Leno show. See, I would have him talking to Jay Leno or Oprah Winfrey. Can you do that? Or are they going to say, wait a minute, it's going to look like we're endorsing your book, right? A publicity violation. Under the First Amendment, there's a lot of protection for editorial uses, but we'll still be careful there and try to make it clear in some sort of parody form, perhaps, make up a name, or change the name, Ronaldo, Overa or something, so the reader still knows we're joking around, nobody's going to think it's really endorsed by him, but you get your point across anyways. The other thing I always will talk to our artists and writers about is that there's no copyright infringement if the only real reproduction of the image or the song lyrics appears in the mind of the reader or viewer. So you can just put a little bit in there, enough so they know what you're referring, and they'll hear the song in the background that you're referring to. Perhaps in a panel, you'll have a radio playing and there'll be one word will come out, and then you'll draw out a lot of static. and then maybe another word. So you only have 2 words with a big space in between. I don't think you'd have any sort of copyright infringement of the song lyric, but it's enough that the reader will hear it in his mind. Same thing with, you know, potential references to other characters or celebrities. And with that, I will move on.
You ready now?
Yeah, I'm ready. Thank you. I love coming to these things because I'm not a lawyer, though I've played one on TV. And I've been, Diane pointed out to me for a while there, I was really doing the circuit. Then I got voted out of office and I got a reprieve from doing the circuit. But I'm very glad to be back here. I was here once before on a similar panel. The thing that comes so clear to me, and this is probably because I'm not a lawyer, is the fact that everything that everyone is saying here leads to the inevitable conclusion that what we need is a federal unified right of publicity or some such thing so that we can clarify this stuff. All of these contradictory decisions, all of the uncertainty, which I know drives people like Jay insane, and also causes people like Jay and what he just described, which sent chills through me, to restrict the creative choices of his writers and artists. And that's obviously not a good situation. But the simplest response that I have is, well, if you're not sure, then make something up. I mean, stop trading on images of people who have spent lives developing value in those images, either through talent or through good luck or whatever, but those images have tremendous value. And to discount that with a sweep of the First Amendment, it seems bizarre to me. We have copyright in this country, I believe, because we inherited it. And I don't know enough about law to know if that's true, but I believe that's true. And it seems to me that we have recognized that there is speech that can in fact be bought and sold, but we want to limit it to, frankly, to the people who didn't create it. Because copyright holders in general in our society are corporations, not artists. And I am a major advocate of rights for authors and rights for artists. And I know that's problematic in the way we do business in this country, so we have to work around the fact that we can't have droit moral in this country that means anything. Because we have so many structures that are based on buying and selling copyright and selling all rights with that copyright. And I know that isn't going to be rolled back. But what we do have to do is recognize the fact that just as corporations have rights that they need to be able to exercise and have just been extended, I would point out, I don't think that, unless I'm wrong with my numbers, I don't think the Gone with the Wind and the Wind Done Gone case would even have existed if we hadn't gotten the Copyright Extension Act passed a few years ago, because I think it would have been timed out. I think it would have been over 50 years. I'm not 100% sure of that, but I think that's the case.
There are a few years left, but it certainly impacts courts looking to expand the public domain because of the length of copyright.
Right, and so, and we were involved, by the way, at Screen Actors Guild, and the entire creative community in the film industry was involved in supporting the extension of copyright for self-interest reasons, but also because we are involved in an industry that the mother's milk of which is copyright. Without copyright, without some kind of controls on speech, you don't get movies made. No one could afford to make them if the material couldn't be controlled for a period of time. We're not talking about life-saving drugs here. We're talking about movies. You know, if people want to talk about drug patents, well, yeah, let's talk about that. But these are movies and television programs, and nobody's dying because somebody's controlling the use and continuing to charge for the use of these products. That may be an analogy which is bogus, but I liked it, it just occurred to me. But I do think the scariest thing that Jay said is that using someone's copyrighted fictional character is much riskier than using a real person. I mean, how upside down is that? I think that there could be, and this is, Diane and I were on a panel together about 2 years ago, where I made this proposal, and I will make it again in this room. You are the people who could actually figure this stuff out. You have all the information, you have all the knowledge you need to be able to figure out how do you structure something that would actually take into account much of what's come up and be flexible enough to incorporate future technologies, because technology has changed in a way that was not anticipated at the turn of the century, was not anticipated in the 50s. People's images can be manipulated, stolen, manipulated, and used in ways that were never conceived of, in very realistic ways, in ways that also, by the way, can be published and distributed without charge, which means that no one is benefiting commercially, and yet the use of that image could have very damaging impact on the ability of that person to continue to have the value of his or her own persona. And the hypothetical I'm most fond of citing is, let's say Michelle Pfeiffer was in a film, there was a trailer of the film on a website. Someone downloads the website, it's got a lot of good angles and images of Michelle. Those images are taken into a software program, manipulated, her head is then put onto the body of a pornography actress, and then let's say a screensaver is published on a website and sent out all over the world. A screensaver, you don't charge for screensavers. People do this as a goof, and you have a little clip, 15-second clip of Michelle Pfeiffer with someone else's body, or maybe even with her own body, which has been manipulated digitally, performing an obscene act, and it's all over the world. Now, there is nothing, the copyright holder of that film, which put that trailer on the internet, is the only entity with status to go after that use, and yet the copyright holder has no interest in going after the use. The entity with the interest, i.e. Michelle Pfeiffer, has no status to go after that use currently, and because there's no commercial use, it doesn't fall under right of publicity, and because it's not, I mean, is it defamatory? Yes, one could possibly say that, but is it artistic? I mean, it gets into all this First Amendment mud, and all I'm suggesting is that there are minds that are currently operating in the legal system in this country in intellectual property, which, if you step back and thought about everything that's gone on in the last 10, 15 years in this area, could come up with solutions to this, and we could have a unified right that is enshrined in a clear federal law, which would do away with all these state laws, do away with all the insane variation, and with all the lack of clarity, which I believe is the biggest problem for commerce and for creativity, is lack of clarity. Thanks.
Diane, you want to respond to some part of that?
Well, I think defamation law actually is slightly better for Michelle Pfeiffer in this case than he made it out to be, Richard. And so I'm not sure that case worries me so much. I think the real question I would have is for all these creative lawyers to get together and write this statute. I think you'd have to have creative lawyers who believe that there was a basis for creating this kind of a property right, and I think that's the problem that I have, is what is the basis for it? If you were to look at the way the same question had been handled by courts in the area of straight privacy, when people objected to the way that they were being portrayed, their names, their faces, and so on were being used on straight privacy grounds. you end up with somebody like Justice Brennan saying, well, you know, exposure to other people and being used by them in ways that you don't necessarily like is just a price that you pay for being part of a society in a civilized community. We don't give people the right to censor how they're presented. And yet, somehow, my point is that by calling it property, suddenly everybody thinks it's okay. And I'm having a problem with why we would do it in the first place. I can understand some of the problems that you're raising, but I think we have techniques to take care of a lot of them without getting ourselves into more First Amendment hot water. And I would also say that it seems to me that what we're really interested in here is in part what it is that promotes creativity. And I think free speech does that to a very substantial extent, and that shouldn't be forgotten, that there's a tension in here between two different ways of going about it, and we shouldn't forget that free speech is a very important component of how we get new works and new ideas.
Well, let's start with the notion of a federal standard. We have one in the Lanham Act. And in the Rosa Parks case, clearly you feel the court missed the boat on the Lanham Act claim and failed to understand the commercial nature. But as an initial issue, doesn't the Lanham Act, as amended following Woody Allen, giving a person a claim if there is a likelihood of confusion as to their association? Certainly they are associated when their head shows up. And if there is that confusion as to the nature of the association, false speech, which I won't speak for you, but we've already kind of recognized an exception to the First Amendment with libel. So how much can we agree that if we put real teeth into the Lanham Act and rely on the Lanham Act, maybe we can back off on some of this right of publicity?
Oh, I think it is definitely a start. I think, as I said, I think the district court judge misread the Lanham Act with regard to even with our declarations and our affidavits, and we think that this was an appropriate case, and I think that might be a good start. The history of the Lanham Act is such that I think that'll be a good way to start in this whole area. And I'd be real surprised. I mean, you're always optimistic, hope springs eternal, but I think that the court, certainly at the argument, was very interested in this, in that very point, where the court did miss the point on the Lanham Act. I think that's one of our strongest arguments, and we'll have to wait and see. But yeah, I think that's a real good start, and I think moving forward would be, and perhaps there could be more team plays.
Jay, does Mad Magazine feel comfortable that their parodies are sufficiently critical and over the top that they'll be able to withstand a stronger Lanham Act challenge?
Yes. I would say, sure. It's all editorial content, plenty of commentary. I don't see a problem unless we start merchandising.
What we're positing, though, is in an effort to cut back on the right of publicity, expanding the Lanham Act in terms of it doesn't matter that it's editorial if it's false speech because people think you must have had authorization or you have muddied the waters as to whether or not the individual implicated is associated with or approves.
Right.
Would you be willing to feel comfortable about that relative to parody and the First Amendment protected editorial content?
I would say so. I would say that there's still could be no likelihood of confusion in any way that any of these people endorsed or authorized the use of their images or likenesses in Mad Magazine. Mad being a premier, recognized parody magazine of this country for many, many years. I do think it would create more of a concern, perhaps on the DC Comics side of the company, where, for example, hypothetical, we have a evil alien being take over the body of a famous rock star, or take over the body of an impersonator of a famous rock star, not the rock star themselves, an impersonator of a famous rock star. On the cover of the magazine, the comic book, you've got Starman fighting this impersonator. Perhaps you have a problem there because people walking into the store would see this what looks like a famous rock star on the cover. And perhaps there'd be that initial interest confusion type of argument that's arising in some of the domain and meta tag type cases where you'd have a Lanham Act claim. So there I think we'd be more cautious. In a situation like that, we'd want to perhaps make sure there was a large enough cover blurb, something like not the real thing but a deadly impersonator, So anybody who sees that image on the cover would also see the blurb right away, and there'd be no likelihood of confusion.
So conceivably, the Lanham Act on that basis doesn't so interfere with your creativity, even if you have to, like in the Wind Done Gone, put a stamp on the cover. And maybe if we add fair use to the Lanham Act, we have less of a imposition on the First Amendment. You going along with this?
Well, I think I could go along with the idea of you making more use of the Lanham Act if we had some rules about what's an adequate revelation of the fact that the person is not associated with this. I mean, if it's a question of making sure you've got it on the spine and everybody knows those are the rules, I'm happy with it, but I was a products liability lawyer for too many years and did too many warnings cases not to understand that unless you have very clear rules, there is nothing you can say, no disclaimer that will ever be enough if somebody doesn't want it to be enough. And I think if we don't deal with that problem of how you make it clear that this is not done under the authority or with, with the agreement of the individual, that we haven't gotten anywhere.
That do it for you?
I like that perfectly well, but I don't know that you do.
But then we're getting closer to a federal standard, but we're still left with the notion that you've morphed the model's head onto the fashion spread. And now a model, Naomi Campbell, gets paid quite a lot to be seen with the fashions. We've got a real opportunity now. We get a good-looking body, and we don't have to have a good-looking face, so I guess that costs less. We put the fashion on the body, and then we import the model or the celebrity's head, and we put on a disclaimer. What then? Isn't there still an unjust enrichment? Aren't we still uncomfortable? Isn't there still a problem that we do need a right of publicity?
Well, I mean, I'm not a big fan of the right of publicity. I want to clear that up. I use that in lieu of anything better. If this could be done through the Lanham Act or any other current complex of laws, as long as there's clarity, which I believe is the greatest impingement on creativity, a lack of clarity. Because when people don't know what the situation is, that's when they restrain themselves in a way that can be truly damaging, I think. But and Diane, you made the point again very clearly by saying as long as there are clear guidelines, yes, it makes sense. I second that completely. What we're looking for here is some kind of clarity, and I understand it's an unclear area of law and meant to be somewhat subjective in terms of the way it's interpreted. But I think, yes, there would be some holes, but those holes could be filled, I think, again, if there is any interest in trying to find a way to come into the current state of digital technology. That's a very and that might not have even been done digitally. I don't know. I mean, that might have just been cut and pasted. But let's, for argument's sake, say it is. You don't need a model to do the bottom. All you need is software. You can create that body underneath with software. The question is, why put that head on top if you're not trading on that person's value? And that to me, that's really what the question is. I mean, why come up with this incredible thing of having an impersonator of a famous rock star because you can't use the rock star when the whole value of having anything to do with the rock star is the fact that the rock star is famous and has value. So there are just ways of working around what is a very real issue, which is that you are appropriating someone else's value, and this is not the same as being presented in a negative light for its own sake, in my opinion. It's a matter of using it for the purposes of making money and hitchhiking on somebody else's value. Now again, maybe Lathem is the most accurate and precise weapon to use in trying to address that. I leave that to you guys.
Well, I think that, in the cases that we talked about, there was a Lanham Act claim for Midler, for Vanna White, there was successful Lanham Act claims, and in most of the cases involving the celebrities, the question, of course, is whether or not an adequate disclosure is adequate, and that can be tested as we do in advertising in terms of whether it's perceived, and as we saw in the Godzilla case, the court should be very strong if it feels that there's an unfair taking. And I personally have a predilection for it, but I'm stymied by the fact that if this were an advertisement for the gown, and a classic paid media insertion advertisement appropriating a celebrity's image, and that celebrity can come in looking at the fourth factor of fair use and argue that this proliferation of the image is undermining the market for authorized uses, for derivative works, if you will. How do we import fair use, as the California Supreme Court was trying to do in SARA, sufficiently to protect that economic interest, or does that go too far and in the violation of the First Amendment as you see it?
Well, I mean, before you even get to fair use, it seems to me you've got to ask the question about what it is that we're trying to protect here. And I think that the issue of the model and the model's head to be morphed onto somebody else's body is actually, in some ways, the most interesting problem. And I think it does exist, whether it's in an ad or it's in editorial content, because if you take the position, as I tend to do, that the most intelligible reason to create a property right is to prevent a failure in the production of a certain kind of good that we all want. In other words, that if people can't get compensated for something that they do, they will not do it anymore, and we will all be a loser. I mean, that is, I think, probably the strongest single reason for recognizing a publicity right. It's my problem with Tiger Woods, because I think he would still be a golf star, whether or not Rick Rush paints his picture and makes 5,000 posters out of it. But I think when you're talking about a model who makes his or her living by wearing clothes and being photographed, and then that becomes a much harder question. And I think that's the place where I would like to have a real conversation about what we mean by incentives here, because I think two things may be going on. One is that you may really be taking away somebody's livelihood in a very direct way. On the other hand, what may also be is on the cusp of a change in the market for how we model clothes, and that maybe we're going to move to computer-generated images as models instead of live people. And I hate to say this, Richard, we may be on the cusp of moving to computer-generated actors too. I don't know whether an audience will buy it, but I think whenever we get to a point where people see their former way of doing business threatened, we get into real problems. I think much of the law governing the internet now is a law that's designed to try to preserve old business models in the face of new methods of communication. And it's very hard to sort that out. I think these are the really tough problems that we need to think about, and we can't think about them if we don't have a good idea of why we think this stuff ought to be protected. And I don't think it's enough to say just because you created the value. Everybody in this room creates a lot of value, hopefully, and they don't get paid for most of it. They don't even expect to. So I don't think that's just not the right answer.
I fear we're getting too close to consensus, and Judge Kaczynski would find fault with me. If he were here, in addition to mercilessly attacking brethren on the Ninth Circuit, which I'm constrained to do because I'm not quite in the same position he is if I ever end up there. One thing he would say is, let's do away with injunction and let the marketplace decide, and let people express themselves as long as they're willing to pay the price. And to what extent do we need to have injunctions to protect the privacy aspect of the right of publicity in terms people who just don't want to be made public, just don't want to be associated, want to control their notion of how they appear in the public and their privacy? Or can we make this an economic issue?
Wow. While you were talking, I was thinking about the discussion earlier of Rosa Parks and the almost sanctity of her persona in this country for everyone, virtually. And I was thinking, would I have the same reaction to the story that Johnnie told if it were a lesser light, if it was a less saintly person? And there, you know, I mean, I know there are people who have never made a commercial and would never, Dustin Hoffman as well, could have used that additional or income period. And he made a conscious choice not to, and he was, it's true, it's not an outright ad. However, I believe there were, you know, as in most fashion spreads, there were listings of who the designer was and what it cost and where it was available. And there's no one, I know this wasn't a fashion magazine, but it was a fashion spread in a magazine. There's no one in this room who's ever looked at a fashion magazine and believed that an editorial spread in a fashion magazine wasn't completely hidden advertising. I mean, that's all it is they're showing you stuff so that you'll go and try and find it and buy it. And again, you know, does it have to have an official stamp on it? I know I'm not answering your question, but perhaps I'm not. It was too complex a question. I'm not sure. I'm really not sure, and that's part of what I've been trying to say here is I know that there are, or I feel very strongly, there are areas in which these issues absolutely or will continue to trouble us unless we can figure out a way to address them. And people are more and more, and I mean all kinds of people, as I'm sure everyone up here knows, that people are more and more concerned with the absence of privacy in their lives. We are under more and more observation in every element of our lives in terms of our private information, in terms of there are cameras watching the streets which can be tilted and panned and zoomed in on any one of us at any time that are set up there for various other purposes like traffic reports and weather, and they also can pick up a robbery in progress. If the operator happens to notice and zoom in on it, it can end up on the news, and they can push right through a window also and look in on somebody changing their clothes. I mean, those things are out there and they exist and people are aware of them. And I think it raises the issue of the burgeoning technology and how we address how it's used that impacts us in all different ways, including the ways that we're discussing here.
So with all the concerns for privacy, we probably have to leave the injunction, at least with respect to the Lanham Act, that permit Rosa Parks to stop what she finds so offensive.
No, I think so. I think it's appropriate. I think in this case, this is a very, you know, as Richard, I think, indicated, this is for them to do this in this case, and you know, this is Arista Records, this is LaFace Records, and they profess to have great respect for Rosa Parks, but if they can do this, I think that there should be that right to seek an injunction in a case like this. And I do think it's maybe a difference in some others because of who she was on certain things, but I think the principle is still is the same. As I said, I think that I believe very strongly in the First Amendment. This case is one that really caused me great concern, I must say. I had no reluctance at all, not only because of Rosa Parks, but I thought if it happened to her, we all could be in trouble.
Well, you addressed Judge Kaczynski in the injunction. Let me mention there is a microphone, and we'll take some questions. If you want to ask a question, would you just line up at the microphone? So after one more comment on injunction, we'll see if you can do a better job of getting some dissension going here than I have. What do you think about it in Judge Kaczynski's notion of let the marketplace and do away with the injunction? Would you at least leave the injunction for the Lanham Act claim for false speech?
Probably not. I don't understand why we use injunctions in some places and other places say that it's absolutely verboten, when the damage made in the First Amendment context can be greater. We aren't going to be able to do it in one area, we shouldn't be able to do it at all.
Mr. Cochran has to leave, so if somebody online has a question for him, let them go first. You can sneak in. Yeah, the teaching gig. Go ahead.
The question that I had was with regards to the concept of fan fiction, which the panel hasn't addressed yet. It's becoming an issue, especially on the internet. It's getting a lot of media attention. And I was wondering how the panel felt about things like the Lanham Act and copyright law and fair use on the concept of something like If the Wind Done Gone had been done not as a for-profit book, but merely as a story that someone had posted on the internet as their own commentary on how Gone with the Wind should have been written or could have been written, complete with little disclaimers saying, absolutely no authorization was implied. Or, for example, a fan of J.K. Rowling writing a story and posting it on the internet where Harry Potter is an American boy, and how would that have changed things if he had been American instead of British, and so on. Is this something that really violates copyright law, or does it still fall under fair use?
Well, it would violate copyright law even as the 11th Circuit ultimately comes out and Wind Done Gone. The answer is in the Supreme Court's decision in 2 Live Crew, and that is that where the First Amendment permits the use of copyrighted material because of your creativity to transformative use, what you have contributed, there are still limits in that the second user can only use as much as is justified and necessary to the commentary or to the point that you're making, and that it will not be tolerated if that use can be shown to undercut the legitimate rights of the author in terms of doing derivative works and sequels. So there would still be a problem under the existing law if your next chapter of Harry Potter displaces in some way the marketplace for the one that J.K. Rowling is coming out with. That's the state of the law today with respect to fair use. Still has to be fair, and it's those two crucial issues that are the limitations.
I'd be happy to comment on that as well. I think one of the points you raised sort of leads to the question, the title of the program, does copyright and rights publicity stifle creativity? And I think you bring up a good point. I think what is stifled to a large degree is not so much the creativity, but the manner or media in which some of that creativity is distributed. I don't believe the cat not in the hat case, if those lyrics have been published in Mad Magazine, a monthly magazine that gets tossed out or just thrown away, or just people might save it, hopefully they used to save it in polybags, etc. But it's not intended to be a book that remains on the shelves. I don't think Mad Magazine would have been sued. I think the particular venue or forum in which that book was published is what resulted in the lawsuit. I think the Wind Done Gone case, if that book perhaps had been published by a scholar, an academic publisher, sort of journalistic format, they may not have heard either. Your question about internet stuff, if somebody just published that on the internet, probably nobody to sue. They kind of shut down the first site, but it would have been shared and sent as email attachments to everybody. So the creativity is not being stifled. And the internet has given a great opportunity for people to exhibit their creativity. But the ability to make money off of those things is stifled to some degree.
See, but that exactly does bring up what I raised before. There is a real danger here in that same sense of people, without looking for compensation, without looking to make money, taking other people's images, manipulating them, and then publishing those images. And again, copyright holders do have status to take action if their rights are violated, and individuals do not in this situation with as clear an outcome. Let me put it that way before Diane jumps on.
My only question is why, if somebody writes an entirely new Harry Potter story as a fan, we couldn't just as easily conceptualize taking those characters in the general setting and making a whole new story about it, a taking of ideas. And that is one of the things to ask, whether taking that general background and writing a new story necessarily displaces anything. It may give Rowling some competition, but that's not necessarily the same as displacing. And I think that's why I asked the question about what we should be protecting.
And does it affect things at all, as Jay was saying, in terms of the context of, you know, if the Cat in the Hat parody had been put in Mad Magazine, it would have been obvious that this was a parody, and if the Wind Ungone had been done in a scholar thing, it would have been obvious that this was a scholarly commentary. If somebody writes a Harry Potter fanfic in a J.K. Rowling fan forum, clearly with the intent of demonstrating their love for the novels and how much they've been affected by them and how alive the characters are, does that become something different from Joe Smith, author out in Midwestern America, just trying to show off his own writing skills, who couldn't care one bit about J.K. Rowling at all?
Well, the acid test is not going to be the intent of the author. The acid test is going to be whether or not that secondary work is causing an economic damage to the copyright holder's market interest under the fourth factor of fair use. And so the point is that if it's ephemeral, if it doesn't really displace it in the marketplace, the 11th Circuit has said, even though it may take copyrighted material, no harm, no foul. Judge Kaczynski would say, certainly no injunctions, just pay the damages after the fact. So there is some scope there within fair use under copyright, and part of our question is, how do we bring fair use into the right of publicity? Next question.
I hate to take issue with the fevered minds of 73 law professors in August. But when I saw that Tiger Woods shot, I was disturbed, and until Professor, you modified later the comment. I represent model agencies, and when we look at images, I see how much they cost. I see these very brief careers of models. I see their problems. They have to feed families, children, save for education, things like that. I see all the shots that they have to do for free to get that one job that pays. And I see also if you could take a photo of a model and degrade it in the way that image is degraded now, you may see that as a fine artist, but when you're creating legal rules, you don't want judges to be able to pick between what is schlock and what actually raises the image of the model. It's either the photographer or the model, I would submit, should have really control over that. So I have a real problem with setting up a legal rule that would apply to a millionaire golfer's control over his image and also be applied to a model's image. And it's not like they have strong unions like Richard's been a fierce warrior for actors, and they have protection, but models are really have very poor protection under the law. And the right of publicity really is the begging for scraps in terms of an ability to legally pursue. We would look at a copyright holder and say, well, if you copied the New York Times, well, you're supposed to get at least a few pennies. Richard's fellow actors would expect royalties every time their images are used, but we look at the Dustin Hoffman photo and we don't think about the fashion stylist or the model whose body was used, and we don't think that, gee, shouldn't a few pennies even go to that person? So I throw that out there in terms of conflicting with gee, that image was free to make. It wasn't. It was quite expensive. There was a lot of labor and art that went into it.
One thing you have to recognize, though, is if you want to write a publicity, and you're going to have to deal with the First Amendment, you're going to deal with the fact that there's no alternative, but that judges will make determinations as to whether or not something is transformative and within fair use, or something is, as the California Supreme Court said about this art, not sufficiently transformative and therefore not permitted to be used, and so. And there's not a solution to that. And as dedicated to the First Amendment as I know you are, you're still willing to tolerate judges being involved in those decisions.
I never said that. The Saturday decision is lousy. I don't know how the California Supreme Court did that. They must have not been sleeping well. The idea that judges are going to sit in judgment on the quality of art is to me so appalling, and I think it's really quite fascinating that if you look at the cognate area in copyright where judges have pretty uniformly refused to grant or withhold copyright protection based on judgments about the importance or the quality and so on of the art. I think it's quite amazing that in this context, the California Supreme Court was willing to take this stance. I think if you read that opinion, what you really have to conclude is they looked at the First Amendment issues. They were sort of constrained to admit that they were actually rather strong, and were faced with a choice of throwing out several decades of right of publicity law or finding some way to squeak out of this, and they found a way to squeak out of it, but I don't think it was a very good way. So I certainly would not endorse this as a solution to the problem. I think in terms of the question that was just raised, let me just say that one of the things about most of these right of publicity cases is that the reason that people want to use these images is not because these individuals are models who make their livelihoods being photographed for these kinds of purposes, but because they have gained some kind of significance in the world in other ways. And it is very difficult to make the argument that they would be less likely to play golf or be bobsledders or skiers or actors or so on if they were unable to collect money for having their image used in other settings like this. And in fact, there are many places in the world where there are lots of celebrities and they don't have rights of publicity. So it is hardly an argument that it's essential to promote participation in sports and so on that we have this additional stream of income. So it's that I'm concerned about, and I think we can talk about the model case. I think it's a much harder case.
It raises an interesting distinction between rights of publicity and copyright. If somebody were to do a similar picture, but instead of Tiger Woods, it's Batman. Obviously, we would not want that to be allowed, but Batman's value is in his imagery, not playing golf. So you've got that distinction.
Well, but isn't it also that, and I go back to my original point, that because it's a copyrighted image, and I'm sure also trademarked, it has property value, which is totally recognized, whereas as an individual some people feel that individuals shouldn't have that same kind of copyrightable or trademarkable image. I know many performers who would very much like to be able to trademark their image, for commercial use, not to keep, any, as the split that Diane mentioned earlier about the traditional pre-1950 or whatever date you set on it, the distinction between what was informational and what was entertainment. They don't want to get into the informational area, just the commercial area. I think that was a great comment, that if that was a picture of Batman or 3 pictures of Batman, we wouldn't be having this conversation. If that was Archie and Jughead, we wouldn't be having this conversation. But because it's an actual living person, that means he's fair game. And that's the thing I don't get, but that's just me.
This has been such a wonderful presentation that I've got about 4 million questions, but I'll try to keep them to one lawyer's question. I would suggest, though, that when you think about the fact that we're free to write biographies about people, famous or not, and whether a poster like that of Tiger Woods or the ones about the Three Stooges, isn't that the graphic equivalent of a biography? And shouldn't an artist be able to do that at will? And shouldn't that supersede both right to privacy and the right to publicity? And I think there's a very important legal distinction. The reason we have problems with these things is because these rights come from different places. Copyright, the origin of copyright is very different than the origin of trademark. The origin of privacy is very different than the origin of publicity. They afford different rights from different places. And I think it's very difficult to find one framework, like even a First Amendment framework, that's going to apply to all of them in the same way. But I do think that the fair use of copyrights, which is the codification of First Amendment considerations, I think, as to copyright, can perhaps be transportable to right to publicity, not necessarily privacy maybe, but certainly to right to publicity. And I'd be interested if you think that can be done and if the cases have gone to that at all. And you could link with that fair use in trademarks, because I think the right to publicity is most likely to trademarks. And a personality can trademark their name, their image, things like that, and use it. And so maybe expanding trademarks to include the right to publicity would be the way to go, because we have an established body of law with respect to trademarks. We have an established body of law, what's too close, what's too similar. We have some kind of established body of law of First Amendment uses, etc. So is that a way to try and expand?
Well, Congress could amend 43A1A of the Lanham Act to incorporate the fair use, and we would have our Lanham Act and fair use, and leaves us with the problem, though, of what about the model who sells his or her image, which would not be protected against a use that clearly avoids a false implication of association. But, maybe that would help, and if Congress would do that and give us more of a national standard, maybe the states would then let up a little bit. Maybe California would back off a little. Interestingly, it is the California Supreme Court, the state court, that reached out to copyright to try to deal with how to keep some part of the right of publicity despite their concerns about the First Amendment, and ultimately conclude, I think also incorrectly, that this is not sufficiently art and transformative.
If for me, the Tiger Woods thing, which is a lithograph, albeit a laughable limited edition, as you pointed out, but is a lithograph and clearly a work of art and clearly designed to be a work of art for sale. I don't have a huge problem with this. On the other hand, the Three Stooges issue was clearly T-shirt art. It was intended, the vast majority of the selling was of the T-shirts. I rather suspect the lithographs were done to provide protective coloration for the T-shirt sales. And for me, that's a very different situation, because I don't think any one of us is going to sit here and argue for the fact that one could, that T-shirts are art in the way that is intended in these various case laws, and they are clearly commercial products.
Well, let me just say one thing, and that is that I think there's a reason why the figure of Batman may be protected and these might not be. In copyright law, we make a distinction between protecting expression of an idea and the idea itself. We make a distinction between protecting creative expression and protecting facts, which are not original and are not viewed as expression. It seems to me that when you're dealing with real people dead or alive, the theory behind copyright, which is that as long as you don't close off the ideas and you don't close off the facts, you can almost always find some other way to say the same thing. If you can't use their faces, how do you say them? And I think that's the real problem.
One last question.
This is a non-lawyer question, sorry, but It's a two-part question, really quick. You've talked a lot about images and the use of fictional characters in written works. But what about, increasingly we see a lot of novels where we have historical characters appearing in fiction. So a question that often comes up is how far can you go? I mean, JFK's dead, can you make him a cokehead? That's question one. Question two, Jay, you've talked about how you have to cope with the appearance of real people in comic books. Is that the same in novels? I mean, people seem to think they have more leeway in a novel to have Mick Jagger come in. They might not be able to make Mick Jagger whatever, kill somebody, but they could, there seems to be more freedom. And is that true, or is that an illusion?
I mean, I would say that freedom is or should be the same. With the comics, you've got some visual images as well.
There seems to be different rules.
But it probably is not really different rules. It's just a little more caution, perhaps, that we're exercising that we need to exercise. So yeah, you would have historic personages in fiction books as well as in fiction comics. And there's case law out there involving fictional use of Agatha Christie or Marilyn Monroe, where the courts basically held the right of publicity is trumped by the First Amendment all the time when real people are used in novels and other works of media like novels, whether they're fictional or intended to be non-fictional. The only potential claims would be things like false light or defamation, but the use of the real people in comic books or in novels would not be right publicity issue.
I may be wrong about this, but I think also that the likelihood of anybody bothering to sue over written word incorporation is much slimmer than their images being used because I think most people would perceive the effect on them to be greater if their images are used in some derogatory
There are
fashion.
scenes, believe me, or not scenes, they're shakedowns, shall we say.
They're shakedowns.
Yeah, yeah. But so you have perfect license to say, to put JFK saying you're doing whatever you want. That's no problem.
Well, if you're seeking legal advice.
No, just the question
let me
becomes a
just
lot.
qualify that.
Right.
And that is that with respect to nonfiction, the courts are pretty strong. The First Amendment will hold that biography is not going to give rise to a right of publicity claim. With respect to fiction, there is a little bit of a question mark because the New York Court of Appeals, again, in the fiction context, has continually said incidental use or de minimis use. So Father Hesburgh appearing as a character in John Goldfarb, Please Come Home, is not a right of publicity claim. But the court did seem to leave open the door that if you took an actual person and made that person the main character of your story, you could have a problem, and then you get into the Agatha Christie case and whether or not you have a sufficient First Amendment justification. So I don't want you to leave here believing that you can willy-nilly create a work of fiction incorporating real people. You still need a lawyer.
Okay.
And on that note, this is the Bar Association. I think we will conclude.